Here in Australia, there's no presumption or rule that a child or children will or should live with the parents equally following separation. The children's best interest is the paramount consideration, and whether living with each parent equally is in the child or children's best interest will depend on the particular facts and circumstances of the family. When a lawyer is trying to ascertain whether an equal time parenting arrangement is likely or in the child's best interest, they'll often ask questions about the parenting dynamic. How well do they get along with their co parent or with the other parent? Is there evidence that those parents can communicate flexibly and in the child's best interest? Can they put the child or children's needs above their own wants or desires? From a practical standpoint, we might consider how far each parent lives from the child or children's school and from one another. We might consider whether the parents' work schedule or where they actually work, the location of their work, whether that might impact their actual ability to care for the children equally. In this video, I'm going to read directly from two publicly available cases. And within these cases, the experts explain and provide their expert opinion in relation to what type of parenting dynamic supports an equal time parenting arrangement. So let's hear directly from an expert. The first case is Bills and Brueggelmann, and I'm going to read directly from paragraph 35. The secondary proposal of equal time shared parenting is not considered appropriate due to the long history of very poor parental communication and the likelihood that the co-parenting relationship with sick continue to be extremely strained. Current accepted research clearly indicates that an equal time shared care parenting arrangement is very unlikely to be sustainable and in the child's best interest unless the parents are able to be flexible, cooperative, and child-focused in their communication and co-parenting. Paragraph 36. As would be apparent, the level of co-parenting cooperation between the parents needed to successfully implement an equal time residential regime is considerably deeper than that required for the successful implementation of equal shared parental responsibility. We no longer refer to it as equal shared parental responsibility, but that is talking about decision making, not time with. For the latter, so decision making, all the law requires is that the parties, in consultation, in good faith, on the occasional basis that major long-term issues arise, whereas the former, so an equal time arrangement, demands their frequent interaction, cooperation, and consensus on a host of both important and menial day-to-day issues. That deeper level of cooperation between the parties is not always presently achievable. I'm about to read directly from Malunas and Malunas No. 6, paragraph 66. You can view this judgment for free using Ostley. The court asked Dr. C.A. several questions about the characteristics of successful equal time parenting arrangements. He mentioned adequate parental capacity, respect for the other parent's parenting, involvement in school and extracurricular activities, flexibility, trust, mutual respect, goodwill, and communication to allow problem solving. Moving from generality to specific family in this case, he volunteered, and I quote, that there is no indication that there is the capacity of either parent to trust, respect, give the other parent the benefit of the doubt, communicate in a manner which will allow effective problem solving. The court then asked him, the doctor, about the long-term impacts on children in such families. He explained that the children who are exposed to high conflict are more insecure, they find it hard to trust, and harder to establish secure relationships in the future. When the children become parents, they will struggle to establish secure parenting practices, and there will be an impact on their personality development. Dr. C.A. was then asked about his experience analysing and assisting with unsuccessful shared care arrangements. He noted that he had experience with such arrangements and was able to discern some pathways forward. Firstly, Dr. C.A. identified the issue of gender. He had particular concerns about, and I quote, boys grow up in an atmosphere of not respecting their mothers and their mother's experience and their mother's emotional sensibility because they've grown up in an environment where their father has been dismissive and conscientious with regard to their mother's experience, end quote. Similarly, for girls who have experienced, and I quote, experienced their mothers to be highly anxious, avoidant, and overprotective, end quote, When those girls become parents, they are less likely to trust, more likely to be insecure, and overprotective as parents themselves. Paragraph 69. When I queried whether he was describing a cycle, he agreed, explaining that the problems are reflected in the next generation's parenting and inability to trust in the capacity of their partner to parent. At paragraph 70, the court said, I allowed counsel the opportunity to further cross-examine Dr. C.A. given my own questions too. So you can see that both experts talk about the need for a flexible and good co-parenting relationship to support that equal time arrangement. Now, to be clear, that's not to say that in cases where there is high conflict, that in every case, equal time is inappropriate or won't be made. Of course, every case is decided and determined on the unique and particular facts of the matter. For example, you might have a situation where the equal time arrangement is reasonably practicable. It's been working for a period of time. You might have children that express that they want that equal time arrangement to continue. And although that there has been conflict in the past, it seems to be working. So it's not like in every situation, if there's conflict, equal time will not be ordered. However, very generally speaking, the court and the experts will often talk about and analyze the sufficiency of the co-parenting relationship, which is relevant to considering whether equal time is appropriate in the particular matter. As always, the content of this video is general information, not legal advice. I cannot stress enough how important it is to obtain independent legal advice from an experienced practitioner if you're going through separation yourself. The purpose of this video is to simply explain that very generally speaking, the sufficiency of the co-parenting relationship is often a relevant factor when considering whether equal time is appropriate in the case, although it's not determinative in every single case.